Next case up for argument this morning is State of Ohio versus Marshall, 18CA0054M. Morning.
Morning, Your Honor.
Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. You just let me know how much time you'd like to reserve, and I'll keep track of that for you. The arguments are recorded, so we ask you to keep your voice up and remain at the podium. And we have read the briefs and are prepared to proceed if you are.
Thank you, Your Honor. May it please the Honorable Court, my name is Attorney Thomas Ryan, representing the defendant appellant Kyree Marshall in this case, and if I may, I'd like to reserve 5 minutes for rebuttal.
Very good, thank you.
So, how do we get here? Kyree Marshall indicted with 1 count of burglary, a felony of the 2nd degree, had a jury trial. She was convicted of a felony of the 2nd degree. She was actually found not guilty. The judge gave 2 verdict forms, not guilty of the actual burglary, but the judge also gave the jury the option of an aiding and abetting burglary, felony of the 2nd degree, of which she was convicted. She was found not guilty of the straight burglary count. She was sentenced to prison 2 years along with post-release control. On her behalf on appeal, I raised 4 assignments of error, and I think independently each of those assignments of error could each and of themselves merit the conviction be reversed and or vacated. So what was the state's case? So what are the facts of this case? So Kyree Marshall was with a friend or a cousin by the name of Christopher Olson. So Christopher Olson was a juvenile at the time of the offense, and the state put him on as a witness, and it seems that the trial court allowed the prosecutor to treat him as a hostile witness because some of the answers appeared to be adverse. So the state put on a couple of police officer, Christopher Olson, who was the juvenile, a detective, and the roommate of the owner of the apartment. So what happened in this trial? So the state goes forward and puts on Christopher Olson, who basically testified that Kyree was with him, the defendant appellant was with him, but she didn't go in the apartment. It was his idea basically to burglarize the apartment because he knew the tenant who lived there and he wanted to steal some marijuana. So police arrived to get some statements as well. There's some hearsay testimony as to the owner of the apartment that wasn't objected to. That may neither be here nor there. But basically, the owner of the apartment admitted that some cash was stolen in addition to their marijuana. So, a couple things here. So I submit there's no evidence here to sustain a conviction, and under my sufficiency argument that my client, the appellant Kyree Marshall, took part in, planned, or conspired as part of this burglary. Now obviously, even under aiding and abetting and complicity...
Didn't Olson testify to that?
He said no. He said no. But they cross-examined him. They testified to what?
That your client, that Mr. Marshall was, Miss Marshall was involved in the burglary.
No, he denied it. On the stand, he denied it. He denied it. But
What did you tell the police officers that?
Well, here's how they were able to get that out. They started cross-examining Mr. Olson what he might have told the police. He said, did you tell the police? Did you tell the police this? Did you tell the police this? So then the state goes to put the police officer on and say, well, didn't Olson tell you this? 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 And what did Miss Marshall tell you? So I submit that under sufficiency, you can't have accessory after the fact in terms of criminal conduct. So you need, for obviously to get aiding and abetting complicity, there still has to be the knowingly, the mens rea, and my client, there's no evidence my client committed any overt act in furtherance of the burglary. So here's what the state did then. So they began questioning the police officer, the detective, and it looks good it's one thing on paper when you read the dry transcript, but if I just can kind of emphasize, basically, under my assignment of error number 3, Officer Wilson identified the appellant courtroom. Prosecutor asked whether he knew that appellant was not being truthful with him. Prosecutor asked, and again, from the video, we know that is not a truthful statement, correct? Referencing the appellant's statement. Officer said, correct. So, then Detective Fitz, who was one of the witnesses for the state of Ohio, who who basically gave his opinion as to the prosecutor's question. The prosecutor asked, Mr. Olson's testimony was not consistent with what they were viewing with the video. That was his testimony. Detective Fitz was asked which of Olson's 4 statements matches up with the surveillance video, and the detective was allowed to answer the first statement that he gave to me. Question. The one that he said Miss Marshall was involved? Question. Detective Fitz was asked, saying they popped off the screen. Detective Fitz, that was not true. Detective Fitz testified that was another lie. Detective testified, you heard the statement of Kyree Marshall to the other officer. And it asked if there were many untruths, and the testimony was, there were also many untruths in that statement. So here, I've been doing this for almost 30 years, and Your Honors have as well. So the only time you're allowed to elicit opinion testimony is from an expert. There's 2 types of testimonies. There's expert testimony, and there's factual testimony. These officers were permitted, through the prosecutor's questioning, the officer and the detective were permitted to elicit opinion testimony as to whether not only the witness, but also whether or not the defendant appellant was telling the truth. Improper. Cannot do it. We have a State versus Boston analysis. One witness cannot testify as to the veracity of another. These are factual scenarios for the jury to decide who's telling the truth. The purview of credibility falls solely within that of the fact finder, in this case the jury. So the prosecutor goes a little further. Wasn't done. Quote, in your training and experience, especially your experience in interviewing suspects, do you have any valid or logical explanation why someone who is totally innocent, who did nothing wrong whatsoever, would lie to the police? Defense objected. Detective said, no, I have no reason why they would. So I don't even know why the prosecutor didn't ask the detective, is it your opinion that the defendant sitting over there is guilty beyond a reasonable doubt? He might as well have said that. He couldn't have gotten any further. And this is just not one isolated incident. It's time and time and time and time and time and time again. It's improper. Can't do it. Obviously, what's the jury going to do? They're going to follow that lead of the officer and of the detective and of the prosecutor. And I've cited numerous cases that supports my position that one witness cannot testify as to the credibility or the veracity of another. The defense in this case, and I love when prosecutors throw around the term at the end of his brief, he said, well, the prosecutor, I used to be a prosecutor, the fabulous words, the fabulous phrases, harmless error and plain error. Well, this is certainly plain error, and it's not harmless error because it affected the outcome of the trial and so prejudiced my client that the jury had no choice based upon the detective's conclusions and opinions that my client was lying and that Christopher Olson was lying on the stand. And aside from that, cross-examination is one thing. There's the whole thing of being able to cross-examine someone on a prior statement, but is that substantive evidence? That's hearsay. So Christopher Olson at no time indicated that my client was involved during his sworn live testimony in front of the fact finder, but of course that was circumvented by the opinion testimony of the police officer and the detective. Getting my fourth assignment of error, defense counsel did specifically ask the court for an additional instruction under the aiding and abetting part. And he asked the trial court to give an instruction, quote, under Ohio law, defendant's conduct as an accessory after the fact is not criminal and cannot constitute criminal conduct, unquote. The court refused to give that instruction. The court failed to do so. Now, I think this is more important here because not only did the court, although there's one count of burglary, the court allowed the jurors to make a determination on the burglary and gave them a verdict for it also under the aiding and abetting of burglary. So jurors have a right to have the complete and full relevant law, and they weren't given in this case, even though defense specifically requested it. So I submit that's error as well.
Did the court give a complicity instruction?
The court
in this
did.
case?
Yes.
Did you give the correct complicity instruction?
Well, it was correct, yes, but not complete. Because obviously an accessory after the fact under Ohio law is not criminal conduct. And defense asked for that. Defense asked for that. And they said, and the court says, no, I think it's complete. And I think that the defense trial counsel renewed their objection on that. So, can't have an accessory after the facts for criminal conduct, so that's fits under number 1. Manifest weight, they were not given the proper jury instructions, and the jury lost its way, especially in light of the fact that the detective and the officer were given opinion testimony. Number 3, I think I went over that as to the opinion testimony. Number 4, the court failed to give the proper jury instruction. I'll try to reserve the rest of my time, if I may.
5 minutes.
And I'm asking time of court to reverse her conviction. Thank you, Your Honor.
Hear from you with 5 minutes of rebuttal left. All right, 15 minutes, let's see.
Good morning, Your Honors. I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee in the state of Ohio. I'll start with the sufficiency of the evidence in this case, and I'll just start with the general statement. At the trial, the state of Ohio actually presented a whole lot of evidence proving that Marshall was not the innocent bystander or accessory after the fact, as Mr. Ryan is saying, that she portrays herself as. She was actually an active participant in this burglary. In fact, the co-defendant, who I'm going to refer to as CO, he was a juvenile at the time of this offense. He told police, actually, that the whole thing was Marshall's idea. She conceived of this whole idea. She had previously known the victim. CO did not, the juvenile. Now, at trial, the co-defendant, like I said, CO, the juvenile, he tried to claim that Marshall didn't know anything about this burglary. A complete turnabout from what he had told police initially, right after the incident happened. At the time of the incident, right after the incident, after he'd been questioned by police, CO told police that Marshall was with him and actually participated in the burglary by stealing a scale and a grinder. She actually entered the apartment. He let her in the apartment. He climbed in the window first, then she goes around. The surveillance video, of course, confirms this. She goes around in the front door. He lets her in the apartment. She comes in and helps him steal marijuana paraphernalia. CO, like I said, told police that it was Marshall's idea to break into the victim's apartment to steal his marijuana because Marshall knew where the victim lived and CO did not know where the victim lived. CO told police that Marshall had actually stolen marijuana from the victim in the past. She'd done this before. CO told police that he let Marshall into the apartment, like I said, by climbing through the window first, and then she came in the door, helped him steal this scale and grinder. I think it's painfully obvious if you look at the transcript that CO was changing his testimony in trial in an attempt to keep someone that he admitted that he calls his cousin. They're so close, but they're not blood cousins, but they're so close that he refers to her as cousin. He was trying to keep her out of prison. She was an adult, he wasn't. He was a juvenile who couldn't go to prison, so it's not surprising that he tried to, at trial, shoulder all the responsibility for this burglary. As I mentioned, the surveillance video told a very different story than what CO was selling at trial and what Marshall was trying to sell to police initially when she was questioned. That video showed CO and Marshall actually walking together to the back of the victim's apartment building. That disproved Marshall's statement to police that she was already at the apartments and when CO arrived and met her there. That disproved that statement. The video then showed CO, like I said, opening the window, pulling out a screen and climbing into the apartment through the window. Marshall's then seen on the video walking around to the front of the building, going into the front door of the apartment complex. Now, Marshall told police that when she went in the building, she went into the apartment of someone called Roosevelt Price. Police actually confirmed that Price wasn't home at the time of this burglary. Then less than 2 minutes after CO and Miss Marshall enter the apartment building, they're seen on the surveillance video exiting the apartment building 2 minutes later. CO testified at trial that after he had gotten done stealing things, he walked out of the apartment and he saw Marshall coming down the stairs from the top floor. But Roosevelt Price actually lived directly across the hall from the victim's apartment, which was on the first floor, not upstairs. So that's inconsistent also with Marshall's statement. But probably the most damning part of Marshall's police interview was her statement that she stayed at Price's apartment after CO left. The surveillance video clearly showed that statement to be false. It showed Marshall leaving the building 2 minutes after she entered, like I said. So the bottom line is the surveillance video is consistent with CO's initial statement to police, that he let Marshall into the victim's apartment and Marshall was part of this the whole time. Marshall never told police anything about CO saying this was his grandfather's apartment. That's something that CO tried to sell at trial, was that he told Marshall that this was actually his grandfather's apartment, so she didn't know anything. Well, if that's really what CO told her, why would she not tell police that initially and claim innocence? But she didn't ever tell police that. In terms of manifest weight, it's not surprising that the jury chose to credit the state's consistent witnesses, the surveillance video, over what Christopher Olson said at trial, and Olson's initial statement, I should mention. In terms of the prosecutorial misconduct, Marshall's objecting to these, quote, improper comments during the testimony of the state's two law enforcement witnesses. This is a plain error standard of review because it was not objected to at trial. In the testimony that Marshall is citing here, all the prosecutor is saying, and all the, not saying, but asking about, and what the police are testifying to, is that many of Marshall and CO's statements are inconsistent, like I said, with the surveillance video. They're simply pointing that out. No authority says you can't point that out during police testimony, that you've got independent evidence showing otherwise, to what the defendant and another witness is saying. That's not an opinion of one witness about another witness's truthfulness. It's just pointing out that it's inconsistent with the surveillance video. Now, the Boston case, the Supreme Court of Ohio case that Marshall cites, is very much distinguishable. In fact, all the cases that Marshall cites along this vein are distinguishable. These sort of sex cases where you have an expert who, in the Boston case, was actually a doctor, a pediatrician, I believe, who was declaring that the child victim in that case was being truthful. In my opinion, that child victim is being truthful. Well, that's the ultimate issue in the case, and that's the issue that the jury has to decide, especially in a sex case. So most of these cases involve witnesses opining on a victim's truthfulness in sort of like a sex case. There was a case where you had police officers talking about, I don't believe the defendant was telling me the truth, and she's sort of making a general statement, was not telling me the truth throughout the entire investigation, that kind of thing. Again, that's not what this is. This is far more specific than that. When you're going through surveillance video and comparing it to what the defendant and the co-defendant told police, pointing out it's not consistent. That's a fact. That's not opinion about truthfulness. There's independent evidence. And again, these sex cases are basically a lot of times credibility contests between the victim and the defendant. And that's why it's so damaging to have a doctor get up there and say that the victim is telling the truth. That's not what this is. And that's very different than what's happening. This case is very different than what's happening in the Boston case. In terms of the accessory after the fact, that was requested by Marshall. That was denied by the trial court. In fact, the trial court actually did give Marshall quite a bit of the jury instructions that her attorney requested, just not that one. None of the evidence in this case pointed to Marshall as an accessory after the fact. The state never argued that at all. But actually, she actively participated in the burglary, and in fact, as I said, conceived of the entire idea, according to CO's initial statement. This was never claimed even in the alternative by the state of Ohio.
Well, it's not a crime, right?
Absolutely not. So, yeah, we wouldn't have claimed it in the alternative, that's true. It was never uttered.
Doesn't this really depend on what we believe the record shows, whether or not there's sufficient evidence from which a jury might conclude that this is
I think so.
appropriate defense? Is that the test here?
I think so, yeah, and I think if you look at it, you'll see that there is not. Now, the Supreme Court of Ohio, I cite the Carver case, a Supreme Court of Ohio case from 1972, I believe. It held that if a trial court properly instructs the jury on complicity, it's not under an obligation to also give an instruction on accessories after the fact. And that's what happened here. The jury was properly and in detail given a complicity instruction that was correct under Ohio law. There was no obligation to also give an accessory after the fact instruction. That's something separate. That's not something that's normally part of a complicity instruction. And I think for good reason. An accessory after the fact instruction actually would have confused the jury. It would have unfairly prejudiced the state of Ohio. And it would have just unnecessarily muddied the waters when there really was nothing in the record to support that. So the trial court did not abuse its discretion. Were there any questions?
Doesn't appear to be any.
Then I would just
4 minutes if you want to.
well, I would just ask that this court affirm the judgment of the trial court. Thank you very much.
All right, very good, thank you. And 5 minutes for rebuttal then, counsel.
Thank you, Your Honor. Once again, may it please the Honorable Court. The prosecutor began his argument by saying that the defense didn't provide anything more than being an innocent bystander. Well, last time I checked, burden of proof remains on the government of the state of Ohio the whole time that burden of proof is beyond a reasonable doubt. But let's not lose sight of the fact what the jury found here. They found Ms. Marshall not guilty of burglary. So obviously, they didn't believe she was even in the residence. They found her guilty of aiding and abetting burglary. What evidence is there of that at all? First of all, the state just conceded there's no such thing as accessory after the fact. What evidence is there? What evidence is there, the mens rea, that she knowingly participated, planned, conspired, aided, abetted, assisted, did anything to further this burglary?
Was she, from what I understand, there was video showing the two of them going into the back. Did the video actually show him going in through the back of the building?
I don't believe so.
Through the window, going out the screen and going in?
No.
So there's no video evidence of her standing there watching this or anything like that?
No, not that I recall, no. No, and
They both went back to the back of the building together.
right. So the defense did put on a witness. They put on the expert from BCI to testify that there was fingerprints taken from inside the apartment. Neither Olson nor my client fingerprints were found. The only fingerprints were found were those of Zach Woodrum, who is the tenant. And by the way, the officer testified, this is hearsay within hearsay, and that's why I hate hearsay. The officer testified that Zach Woodrum told him that he knew Christopher Olson, but did not know who Appellant was. So any ties about her breaking in there previously or this or that, there's no evidence of that. Pure speculation. It's pure speculation. And again, take issue with the state's talking about here, how this is not, he says, a fact about truthfulness. Well, let's not lose sight of Boston. The U.S. Supreme Court in this law has not changed since 1989. And Justice Brown wrote in the opinion, quote, "In our system of justice, it is the fact finder, not the so-called expert or lay witnesses," so it covers both, "who bears the burden of assessing the credibility and veracity of witnesses." I submit the state of Ohio here, through their elicited testimony of the officer ad nauseum and the detective again and again and again and again. CO's lying, appellant's lying, they're lying. Who is the jury going to rely on? They're going to rely on the state. They're going to rely on the detectives who investigate the case as to their opinion.
And all these videos are admitted into evidence, so they're going to be there.
Yes, yes. So there's not the mens rea, there's not the knowingly, there's not the evidence that she committed any sort of overt act. Again, not guilty of the burglary, guilty of aiding and abetting on a burglary. I submit, based upon all the arguments I've raised in my brief, that her conviction needs to be vacated and reversed. Thank you so much.
Other questions? Thank you both for your excellent arguments here today. The court will take the matter under advisement, issue a decision in due course. The clerk reports will mail each of you a copy of the decision once it is released, and the opinions are posted on the Supreme Court of Ohio's website. Thank you both.
Thank you. Have a good day. Thank you.